Now, conversely, Peter having delivered his paper in respect of the contents and validity of the notice, John Warren will deliver his paper in relation to the discrete issue of, but important issue, of the service of rescission notices, so as to preserve their validity and so as to preserve the client's interests when the notice, assuming it's valid, comes to be served. There are many situations that I've been involved in and have known about anecdotally where incorrect service can permanently affect the interests of the client when attempting to determine a contract for sale of land. John Warren gets less time to speak, but that's because he's being punished for being late. His excuse was a late train, a bit like a school excuse, but this prefect ain't buying it. So he cops 10 minutes penalty, but he says he can finish in any event, so it's not really a penalty. John holds a JD from Melbourne University, a Bachelor of Arts degree and a Bachelor of Public Policy and Management. He was admitted to practice in the state of Victoria in 2007, and soon we can say he was admitted to practice in Australia in 2000 and whatever. He signed the bar roll on the 22nd of May of 2008, so he's a baby barrister, but that's not to detract from his qualifications to address you today. He was at Middleton's for quite a while, and included in that was his experience in the BHP Billiton against SO case arising out of the explosion at Longford. But more importantly and relevantly for today, he spent quite a bit of time working at the Victorian Titles Office, and that would eminently therefore qualify him as having a practical experience upon which to base his address to you today, and I commend John to you in that capacity. Thank you.
Well, thank you very much. I've presented a short paper. I wanted to, after Peter's very scholarly approach, I'm emphasising some of the practicalities of default notices and particularly the service of them, and I'm going to comment on some of the differences between the old standard contract and its use of Corporation of Table A and the new standard contract. So I've presented 10 do's and don'ts in this paper, so I'll make my way through them now. Once you've got the perfect default notice, the last thing you want to do is bring all that good work undone by making an error when it comes to serving it. So, first things first, if you're going to serve a default notice, please wait until there has been a default. Now, if settlement's scheduled for 2 p.m, and you come back to the office at 3 p.m, where it didn't happen, you don't have a default. You've got to wait until the entire day has finished, and then on the following day, now you've got a default. So, firstly, please do wait until the entire settlement day has passed, and do not draft your default notice until, you draft it, but don't date it or serve it until the following day. Secondly, please do get, and it's not strictly to do with service, but please do get rid of your old precedent that refers to Table A of the 7th Schedule of the Transfer of Land Act, so on and so forth. As Peter's just explained, getting the right condition in the contract, citing the correct condition, is extremely important. Right now I'm involved in a proceeding where I'm attempting to say that a default notice is invalid because the contract was under the new provisions, the new standard contract, and yet the default notice refers to Table A, which of course has now been repealed and in any case doesn't apply to the contract in question. So granted, the authorities that Peter's gone through and everything I'm pretty optimistic that that notice will be found invalid. And I mean, it just causes me to wonder. I wonder how many notices are flying around the city at the moment that make that error, that are actually where the old precedent has been used by whichever firm has issued the notice, refers to Table A, but the contract is under the new provisions. And it's a bit alarming to think how many there might be flying around. Not your firm, I know. The firm down the road, they've got to be careful, right? So please make sure that you change your precedent, or you probably have matters where there's a contract under the old terms and some others that are under the new ones. So make sure there's a second precedent. Do whatever you need to do, and make sure that if you're under the new contract, you're referring to General Condition 28. If you're under the old contract, you're referring to Table A. Thirdly, do note that you can now serve the default notice on the other party's conveyancer. This is a change. Under Table A, under the old General Conditions, I think it was the old General Condition 13, service had to be done on the party or the solicitor named in the contract. The relevant General Condition now states the following. 17.2, any demand notice or document required to be served by or on any party may be served by or on the legal practitioner or conveyancer for that party. It is sufficiently served if served on the party or on the legal practitioner or conveyancer, A, personally, B, by prepaid post, or C, in any manner authorised by law or the Supreme Court for service of documents. So there's two significant changes here. Firstly, the conveyancer can now be served. Previously, it had to be the solicitor. And the second difference is that the legal practitioner can be served, but it doesn't specify that it has to be the legal practitioner named in the contract. So now, I think it's one of my subsequent points, you can serve the legal practitioner who you know is acting for the party, even if they are not named in the contract. Now, you still might be prudent to use an abundance of caution, and I mean, you'd want to be really certain that that is the solicitor, or if there's been a change of solicitor, if one's mentioned in the contract but they're no longer acting, just make sure that you know exactly what is going on. But do note that service can be effected upon a legal practitioner who is not named in the contract, assuming that practitioner is acting for the relevant party. So that's the new general condition as relates to service, and be aware of those changes to the old general conditions. Number 4, I've said, please do serve your default notice by fax, but make sure that your cover sheet complies with the Supreme Court rules. Now, this is another one. You'll see in the footnote what the fax cover sheet must contain under Supreme Court Rule 6.07 and 2.1, and it's got all those things there, which makes me wonder how many default notices have been faxed by a secretary or by a practitioner themselves that were missing one of those details. Yeah, possibly more than one. I know it's not your firm. I know it's the firm down the road, but please make sure that any document you serve by that your default notice, or indeed any other anything else that you're serving by fax, that your cover sheet ticks all of those boxes. Service by fax is deemed to be instantaneous. Well, instantaneous in that once the fax machine at the other end has received the communication, then service is effected. It doesn't have to print out at the other end. All that has to happen is that the other fax machine receives the communication, which makes sense because another party could avoid could avoid service by simply taking the paper out of their fax machine. So the rule is that the fax machine receives, the moment the fax machine receives it, service has been completed. Do serve by fax, but make sure you tick those boxes there. Fifthly, I've commented on how you can now serve a solicitor who's not named in the contract. Sixthly, don't serve your notice by DX unless there's a compelling reason to do so. Now, you can, but I'm advising against it. The Supreme Court rules permit it, so that's why you're within your rights to do so. But the thing is that service by DX is not easy to prove. So if the other party does not admit that the notice was received, then it becomes quite awkward proving to the court that service was effected. So you'd really want to have a strong reason for doing it. And if the good folk at DX or who are moving your notice around make a mistake, then there's the deeming provision, which I'll come to regarding ordinary mail, doesn't apply. So it's when it actually did arrive, and that's out of your hands. So please avoid using DX unless you've got no other option. Number 7, don't think that time has begun to run until service has been effected. My mistake. The defaulting party has 14 days from service, not from the date of the notice, but from service of the notice. So please don't try and wind the other side up on the 14th day after the date of the notice. If you served it by ordinary post, then they've got a further day. And then I've quoted the new general condition 17.1. Any document sent by post is taken to have been served on the next business day after posting, unless proved otherwise. And that's and for me, that's another reason to use the fax machine rather than post it. And post it as well, but unless proved otherwise. So let's say that, it's out of your hands what Australia Post does. So if the other party can prove otherwise, and you wouldn't know what happens, what they can and can't prove, so avoid. I would say that the fax is a better way to serve, but if you are using ordinary mail, that is the rule. Service is taken to have happened on the next business day after posting, but just be aware that if it can be proved otherwise, then the defaulting party is within their rights to prove that to the court. Number 8, do serve every purchaser if there is more than one. To not serve all of them is highly likely to be fatal to the validity of your notice. So if there's more than one party named in the contract, it doesn't matter how many people you're dealing with, everyone named in the contract must be served. And if that makes it hard, because one of them's overseas but you're dealing with someone who's here, then you've got to find a way around that. So make sure that every purchaser does get served with your notice. Ninth, do serve the original purchaser if there is a nominee. Serve the nominee also, but it's essential that service of the nominee is optional, but service of the original purchaser is essential. Service of both is probably a good idea, just so everyone's aware of what's going on, but make sure, whatever you do not leave the original purchaser off. 10th, and this is the point that Peter picked up on, is at the end of his talk, do change your template if the penalty interest rate changes. The new General Condition 26 provides that the interest payable on money owing during the default period is 2% above the penalty interest rate. So if you're specifying the incorrect rate, does that invalidate your notice? Here's a thought. Let some other practitioner be the one who makes the precedent on that question in the Supreme Court. Let it not be you. How about you get it right and let somebody else get it wrong, and some judge in the future can decide that question. Let it not be your notice that is the one that everyone's talking about in a couple of years' time. Now, in a busy practice, keeping track of what the penalty interest rate is probably not your highest priority. But if you are going to specify an interest rate and you're using the new standard contract, be aware that the contract says that the interest rate is 2% above the penalty interest rate. So you can say interest pursuant to the contract, but I think it's preferable to name the actual interest rate because, as we've seen with the judicial comments saying that we're dealing with lay people, not lawyers, and everything like that. Could a lay person be in doubt as to what the amount is that they owe when they look at a contractual provision that the interest rate is 2% above the penalty interest rate, da-da-da-da-da? Look, probably not, but let's just, out of an abundance of caution, specify the interest rate and not give the other side the use of that argument. So use Peter's precedent, but before you fire it off, just make sure that if the penalty interest rate has changed, that your nominated interest rate is 2% above the penalty interest rate. I would think that if the penalty interest rate moves down and the specified interest rate in your default notice does not move, and therefore you're asking for 2.5% or 3% above the penalty interest rate, I would think that I would love to have a crack at that default notice. I think you're in quite a bit of trouble if you're asking for more than 2% above the penalty interest rate. In the other direction, that's interesting, but if you're asking for more than 2%, I'd reckon you're on very, very thin ground at that point. Do make sure that you're asking for the correct the correct interest rate being 2% above the penalty interest rate. The new standard contract, if you're, I understand that the general conditions are now often, even though the contract, the particulars of sale, will explain that the general conditions from the new standard contract apply, oftentimes in practice those are not attached to a contract document because just the way the new standard contract is structured. So if you're ever dealing in that situation, you've got to find them. we all knew where Table A is, but the new standard contract's actually found in the regulations to the Estate Agents Act. So if ever you're in a great big rush and you need to find it, you need to go to the regulations to the Estate Agents Act, and you'll see Estate Agents Contract regulations. I think it's 2008, and you'll find your general conditions there. So that's what I wanted to say, focusing on some practical concerns with default notices. I decided not to tried to avoid using the word rescission once, because I want to get into the habit. We're now talking about default notices rather than rescission notices. So that's all I wanted to say, and we'll have some questions now.
Yes, if you could give John a round of applause. Our late student has certainly redeemed himself by his brevity and his succinctness, I'm sure you'll agree. So you don't rescind anymore, you default. We've now got, because of that, both excellent succinct presentations, we've got 10 or 15 minutes for questions if you're interested. I'd ask you to keep your questions, if possible, relevant to the relevant speaker's paper, although obviously there's a synergy between the two, so there can be some crossover in terms of answering. I've got two to start the ball rolling. One of Peter Little. You refer to Judge or Justice Campbell, I'm not sure which, in Robinson and Bacata. There's a Justice Campbell in Queensland, there's no Justice Campbell in Victoria. Does that refer to Judge Stuart Campbell of the County Court?
No, it's a New South Wales case applying situations in Victoria.
Oh, I see. Justice Campbell of New South Wales Supreme Court. I see. Okay, thank you for that. Secondly, for John, you spoke about various forms of service. Is the day coming soon when we can serve by way of scanned email attachment?
I might have already arrived. You have to check the electronic transactions.
Oh, I see. Okay. Well, there you are. We better check the Electronic Transactions Act, as well as going to the Estate Agents Act to find the general conditions of contract. Things are meant to be more simple. Yeah? Yeah, okay. That's my questions. What questions do we have of the speakers? Yes, at the back.
I have a question in relation to...
Could you stand up, please?
The question is for John, and
yes.
It's where you've got multiple purchases and you're serving all of them, and one is overseas. So does the time then run from when the very last purchaser was served?
Oh, absolutely, yeah. Because if the last purchaser is able to, make good, and they're denied the opportunity to do so, I'm sure that would be that would have to be fatal to
Sounds like an ongoing problem, that one. Further questions, please. Yes.
If you, John, if you're served by fax and follow it up with a letter, which day applies? Or say you serve one person by fax and somebody else by mail, how do those cross over?
John, do you want to come up here and answer? No.
So just to clarify, we've got one purchaser and we're serving them by fax and by post.
Yes.
17.2, any demand notice or document required to be served by or on any party may be served by service on a legal practitioner or conveyancer. It's sufficiently served if it's served on the party or on the legal practitioner in any ABC in any manner authorised by the Supreme Court. So if it's validly served on the day that you send the fax, then now then we go to no, yeah, that's what I'm trying to say. I'm just looking for the right term, because the default notice says that it's you have 14 days from the service of this notice. So if it was served by fax machine on the 1st of the month, then you've got 14 days from that day of service is in the day that the fax machine sent its transmission. So I would say that time runs from the sending of the fax, and I think that the sending of the letter as well does not give the does not give the party in default an extra day. But again, why don't you let someone else be the one who, has to have their notice scrutiny, under scrutiny in the Supreme Court. So, yeah, it's from the fax, I would say.
The answer to that last rhetorical question by John, probably that it's already in the pipeline. Any further questions? Yes.
One question to Peter. In the context of the amount required to be paid, having to be one of the essential components of your default notice, what do you think the position might be in, say, a large commercial transaction where your balance of purchase monies might be 20 million, but when you look at the adjustments, it could be 22, it could be 18 million, something like that, after looking at the special conditions and all the different things you have to account for. So it won't actually be in your notice, you'll just specify what the balance of purchase was without some accounting for all those calculations.
That's right. I need to repeat the question in the microphone for the camera. The question that's been put is, if I can succinctly put it perhaps in a different way, in a rescission notice, you may be able to identify the exact amount that is in default for the purchase price, and or if there's something in relation to the deposit. But you won't know your adjustments until very close to settlement, if at all, and whether they're accurate or correct. And obviously, there may have been some other variation involved. For example, some already been granted an extension, and there could be penalty interest rates with that. So you'll see in the rescission notices, there's normally a phrase at the end which says the net balance being this amount, plus interest, plus adjustments. And the question was put about, well, what about a large commercial transaction where there's a lot of money involved and therefore the adjustments by default is also significant? The answer to the question is that the courts take into account that aspect of adjustments. They don't prima facie, other facts otherwise, look to that have to be specifically defined for the purpose of the rescission notice. So it's understood, and almost all rescission notices that are valid will say plus adjustments. So, for example, in my hypothetical Appendix 1, I have put what needs to be rectified, and I've said plus the remainder of the balance, which is the purchase price, plus or minus adjustments of rates and taxes on settlement due. That way, it would be my submission that that's covered in those areas of adjustments, which would be perhaps not be able to specify it at the date of the rescission notice. You then can ask a corollary question, well, what about other types of costs? Well, the simple answer is it depends on the factual situation. Have I answered your question?
Yes.
My question is to Peter, in a plus GST sale, right?
I didn't want this question. I knew this was going to come. Yes.
Do I get an extra point?
I answer it, do I get mine?
In a plus GST sale, of course, that's a bit difficult because you need to put GST on the adjustments. So purchaser normally does the adjustments. You need to serve a default notice. How would you deal with it?
Yes.
Yeah, and of course you've got to serve your tax invoice.
Yes.
Otherwise you can't collect the GST.
Yes, the question is one revolving around GST, and in particular GST on adjustment issues. Whenever the GST arises in any situation, when I'm acting in a professional capacity, I start off and preface everything I say by saying, I'm not a tax expert, you need to get tax advice, speak with the accountant. Having said that, and don't rely upon anything I say about taxes, we joke about that, but to me, it's a complicated area. Now, to be specific to your question, I would put plus GST. Now, there's 2 points. First off, if we're talking about adjustments, I don't think you necessarily have to state plus GST in your rescission notice. You can just leave it as adjustments dealing with tax and other matters. And in my submission, the GST issue comes out of the contract and the interpretation of the contract. It's implicit that the rescission notice already takes into account the contract, and therefore the adjustments in the rescission notice has to be taken into account in the context of the contract. That's the first part. Second part, to cover that point, if you are certain that there is GST aspects on it, you could put adjustments plus GST. Does that answer your question?
But I think it's putting the cart before the horse, because you've got to actually give a tax invoice to the purchaser before you can actually say this amount is being owed. So do you then serve a tax invoice with your default notice?
No. Well, other people are shaking their heads, and they're probably far more informed than I am about the tax requirement for GST. The simple answer, in the technical application of a requirement for GST purposes, I don't know, and I wouldn't want to give advice on that area. Having said that, though, prior to settlement, assuming everything being the same, let's say the settlement was going to go ahead, you'd still have to provide that relevant document. That'd be correct, wouldn't it?
Yes.
And so therefore you have provided it, either way, for you to...
No, I'm sorry. You say to them, this is what I'm going to provide at settlement. So you give them a copy of it,
That's
but it's not delivery of it.
Yeah, that's in your... But in your notice of adjustments, you've put what the amounts are going to be.
Yeah, but I'm the vendor. I haven't done the adjustment.
Well, you would have checked them or referred to them. Or
If they've been done.
yeah, yes. Well, that may be right, but be that as it may, if you can't ascertain what those amounts for reasons outside your own control, the other side may not have been worked in assistance with that. Then you can't put an amount. Therefore, you can't serve it accordingly. So, to satisfy. I think the point that you also will come up is to rectify the default, it's not only the amount plus the notices. That may be the answer to your question. If there needs to be for GST purposes, the proper rectification to put the parties of what they would have been in the settlement, they require the relevant tax invoices plus the amounts.
That was the problem in Burke and Riversdale.
Yeah, well, that's an interesting case, but that's a couple of years old now. Does that coincide with? Yes.
Eric, have you got any more of those tricky little questions that no barrister at this bar can possibly answer? Maybe the property section of the Law Institute can, but any other questions? Bruno.
Oh, Peter, with regards to faulty default notices, which generally can be rectified by sending a fresh default notice, are there any type of defaults in a rescission notice which would give the purchaser some immediate rights to exit, etc.?
Well, so the purchaser wants to be able to exit the contract?
Well, you've got situations where obviously the purchaser may be wanting extra time for finance, etc., but situations where a vendor's default in their notice is so bad that gives the purchaser some exit rights where he can get a refund of his deposit.
Well, I would first off say that can't go. The question is, if the rescission notice is so bad that it obviously has no validity, but the purchaser first off wanted extra time but now wants to remove themselves from the contract, the issuance of a bad rescission notice won't give the purchaser a right to terminate. If the rescission notice is invalid, it just has no effect. Therefore, the contract is still on foot. One of the side issues, though, with a default or invalid rescission notice, it may not give the vendor the right to terminate, but it can give the vendor the right to say the time is of the essence, and if the purchaser cannot settle within a short time period after the rescission notice, the vendor has a second argument to say that the contract is repudiated. So the answer to your question is, in my view, there's no extra rights because of a faulty rescission notice for the purchaser. but I've expanded upon that to be careful for the purchaser to also say that unless you are ready to act within a short time period after the rescission notice, your inability to act can be an intention, evince an intention not to fulfil the obligations in the contract, and the vendor then has a second right to argue repudiation.
Time for 2 more questions. Yes.
Service on a conveyancer.
This will be for John.
Yes, John. Service on a conveyancer. Does the conveyancer have to be licensed, or simply the person named in the contract?
Well, General Condition 17 simply says that you can serve a conveyancer. I'll check again to see if there's a definition of that word within the general conditions. Would be surprised to find one, frankly. Yes, so I should check that before I answer definitively. But without a formal definition, then I would think that the ordinary usage of the word would apply. So I wouldn't think that the conveyancer, I would think that an unlicensed conveyancer could still be served. Yeah, so a few qualifications to my answer there, but I would think that that service would still be valid if it was done on an unlicensed conveyancer who happened to be acting. I should, on the previous question, I should note that one of the things Peter and I looked at in preparation is an article by Russell Cox, who most of you know Russell is one of the great authorities in this area. He argues that adjustments are not relevant, but he doesn't cite an authority for that. That's in an article, it'll be about a decade old, isn't it? That one. So that's what Russell thinks. Well, he thought a decade ago, maybe. So, for what that's worth, it's from Russell. Probably.
Last question in the formal session. Yes, this lady here. Service for John. Yeah. John, come back.
Your contract you can't serve on today default if you have a contract with a time limit.
Question was if the contract specifies that that you have to complete at, say, 2 p.m. on a particular day, do you therefore have a default at 3 p.m. and allows you to serve later that day? Probably, but let someone else be the one who finds out definitively from the Supreme Court that, actually no. Oh, oops, you know, let it be someone else. So, but probably.
Because I'm opening our case in the 20th day of a trial I'm running, I can't any longer chair the formal session. 2 options. One is just for me to leave and you keep asking questions. Alternatively, the speakers have indicated they're happy to informally have questions put to them over breakfast, which is who wants? Yeah, my learned clerk is suggesting the latter, and I fully agree. So can I ask you to join your hands and again thank our erudite speakers.